Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center here in Boca Raton, Florida. This is episode 96 of Business SOS. Thank you for listening. If you're new to the show, welcome to the show. And if you have been with us for a period of close to 2 years, thank you for listening and supporting the show. Hope you find value in the show. Hope it has been helpful to you through your business journey. So today I'm going to talk about something more positive. I won my case. What next? So if you recall last week, we talked that I actually had a trial last week. It fortunately went our way and our client prevailed. So I'm very happy and very proud about that. The other side, the plaintiff's counsel did a very good job in prosecuting the case. Unfortunately, the facts were not in his client's favor, but it can go either way. So we'll take the victory. Very proud of our accomplishments, and then, move on. So what happens after that? Say you won your case, and what happens after that? So I'm going to talk about that today. If you win your case, there are two things. Either you will be going to be the plaintiff suing for something, whether it's money or an injunction or some type of relief. If you are the defendant, you're suing to prevent that plaintiff from collecting money from you or for getting the relief that he or she is pursuing. So, winning could mean winning a money judgment, injunctive relief, or dismissal of the claims. In our case, we're defending a claim. We're seeking the dismissal of the claims. We're able to achieve that for our client. If you have a money judgment, for example, what happens? You get a final judgment from the court that the court rules in your favor. The court will enter what is called a final judgment. It is usually prepared by your attorney based on whatever award the court presented to you. It's a money judgment. It will be a certain amount of award money, plus perhaps prejudgment interest from the time that you file the claim to the time of the litigation when the judgment is entered, and perhaps also attorney's fees and cost. So that is prepared in something called a final judgment. And there's a specific format, a specific language we have to use in order to be able to be enforceable. We'll go ahead and send that to the judge. We usually send that to opposing counsel to review it to make sure it's accurate, that reflects what the court ruled, and then we'll go ahead and submit it to the court for signature and for approval. If the courts approve it, you do have a final judgment, and you become a judgment creditor. What does that mean? As a judgment creditor, then you have the ability to enforce that judgment. You have, and the judgment, I believe, is good for 20 years, and then you have to do certain updates at a period of time. The reason I say that is I'm not a collections attorney per se. At some point, I'll bring one here to give us more details on how to do that. But the judgment is good for a long time, and I believe it's 20 years. But one thing you should do is record that judgment in the Florida Judgment Registry. It's only $20. It's good to do that way. The judgment shows up on the credit reports of wherever the judgment debtor is. So it's good to have that judgment recorded. It's already in the court record as a recorded judgment. You want to go a step further, and your attorney can help you with that. If you are the defendant in this case and you get a dismissal of the claims, and if the dismissal is based after a trial, very likely it will be a dismissal with prejudice, meaning that the plaintiff cannot bring that cause of action again against you. And then the question remains, if you have that judgment that you prevail in the litigation, it's whether you will have attorney's fees and cost awarded to you as a result of winning the case. So there are a number of ways you can obtain attorney's fees. If you're in a breach of contract claim, for example, you are the defendant and you're being sued, then the question is whether the contract that is subject to a litigation has an attorney's fees provision. And if the answer is yes, then you should be able to recover attorney's fees for prevailing in the action. If the answer is no, then the second question that I have is whether or not the lawsuit deals with a statutory claim. And in some statutory claims, you have reciprocal attorney's fees. An example of that would be a civil theft claim, for example. We have reciprocal attorney's fees. Florida's Deceptive Trade Practices Act has also attorney's fees provision. There's some statutory claims that have attorney's fees. If you don't have any of those as a third option, which in this case, we actually utilize this mechanism to recover attorney's fees from the plaintiff if we prevail in the litigation. And that's what is called a proposal for settlement or an offer of judgment. It is utilized frequently by litigation attorneys. What it means. We send a proposal for settlement, exactly what it means. Say you're being sued for $100,000. So we don't believe that particular lawsuit really has merit. That when the facts are presented to the court, that it is very likely that we will prevail. We're very confident about that. So we sent something to the plaintiff, a proposal for settlement form that we have, attorneys have it, and it said, we're willing to pay $1,000 to settle all the claims. And they have 30 days to decide whether or not they want to accept that. By sending that proposal for settlement, it sends to the other side, opposing side, it sends a number of messages. One message is that we don't believe your case has merit. We believe that at the end of the day, we are going to prevail. And the second message that we'll send them is that if you lose the case, if you're not able to prevail in this litigation, your client was going to be liable to us for attorney's fees and costs. So there's a risk involved to the plaintiff for pursuing a claim. If they don't have nobody's going to have 100% certainty. But if you don't have good amount of confidence that you have a good case, your client is going to be at risk for those attorney's fees. And they have 30 days to make that decision. And if in 30 days they do not accept that offer, then it's considered rejected. You don't have to file that. You don't file a proposal for settlement in court. Just hold it. You basically file a notice of service, proposal for settlement. You go through the case. Say you win. You have litigated the case now for over a year and a half. So there is a significant amount of attorney's fees that the other side will have to pay back. Now, there's one point that I forgot to mention on a proposal for settlements. What it means is that in order for the other side, the plaintiff in this case, not to be liable for attorney's fees, they have to obtain a judgment 25% over the amount that you're offering. So I'm using that example, so they have to be able to get 25% over that. If they don't, they're going to reject it. If they're suing for $100,000, you are offering $1,000, it's going to get rejected. But in some cases, the amount is different. The amount could be $50,000, so that's a significant amount to offer. But they have to be able to get that judgment 25% over. Say they get a judgment for 15% over the amount. They're still going to be liable for attorney's fees. And the reason for that is the court is encouraging people to settle their cases. They want people to the best they can settle their cases. So if the court looking at this said you had the opportunity to settle this case for this amount and you were not able to prevail and get over that 25% threshold, then you got to pay the other side's attorney's fees. Okay, that's really more inside baseball. The attorney can explain that to you. The point is, it's another mechanism that is available to collect attorney's fees. Another mechanism also to collect attorney's fees, which is not used very frequently because it's difficult to obtain. It is under Florida statute 57105, what is called a motion for sanctions and attorney's fees. What it means is that if you feel that the lawsuit is completely frivolous, then the attorney receives what is called a safe harbor letter, along with a draft of the motion that is not filed with the court. In essence, telling the other attorney, say, we believe this lawsuit doesn't have merit, but it's completely frivolous. You're not going to win on the facts. You're not going to win in the law. And you have 21 days to withdraw this motion, to withdraw this complaint, this defense, whatever the case may be. If you don't do it in 21 days, then you can file that motion. And if the court agrees with you, then the attorney has to pay half of the attorney's fees, and his client has to pay the other, also attorney's fees, the other half. So it's really, it's also putting the attorney in a position that he or she will have to pay attorney's fees if the court agrees with that motion. Those are rarely granted. They're granted yet, but they're rarely granted simply because all the attorney needs is a good faith basis to pursue the claim or defense. And you got to have a very high standard to be able to achieve that. It is not impossible, but it's a more difficult route to take. So there are 4 mechanisms to get attorney's fees. So say you have attorney's fees, so the next step for that is to file a motion for entitlement to attorney's fees and have the court award the attorney's fees to you, to your client. In that case, my client. And usually what you include a statement of a copy of the bill. You have an affidavit of the time you spent on the case. We also have an affidavit from another attorney, which is not part of the case, certifying that he or she has reviewed the file, reviewed the billing statement, and that is fair and reasonable based on the criteria established by Florida law for entitlement to attorney's fees. You put an affidavit of damages and attorney's fees as well by the client, and then that is all submitted to the judge for consideration. Now, usually in these cases, what we do is negotiate with the other side and said, do you agree with this amount of attorney's fees that we're seeking? If the attorney says yes, then all we need is an agreed order that this has been agreed upon and there's no need for an evidentiary hearing. If the other attorney feels that these fees are excessive, that we should not be entitled to these attorney's fees, then this amount of attorney's fees, then we have to have an evidentiary hearing for the court to determine what is the amount of attorney fees that should be awarded. Usually in this case, you got to bring another attorney to act as an expert witness on your behalf to testify that the attorney fees are reasonable based on the amount of work and time that's spent on the case. But it is also a risk for the other side to challenge the amount of attorney's fees you're seeking, because attorney fees will be awarded. The question is the amount. So if the judge awards attorney's fees, the judge can also award the time, the expense, and the expert fees involved in having that hearing in the first place. So those attorney's fees escalate. So I wanted to share that with you. So yes, there's still a process after you win the case to get those attorney's fees. Now, let's talk about the judgment part of it. You won the judgment. How do you collect? It's a whole different conversation altogether. That will be subject for a different podcast, but I'm going to touch briefly on that. So as part of the judgment, we include, the judgment is a court order. We include also a statement that says that the judgment debtor or the defendant must submit what is called a fact information sheet. And I cover those in prior podcasts. I actually cover 1.977A, 9.977B. A is for individuals, B is for businesses. and they have 45 days from the date of the entry of the order to complete the fact information sheet and provide bank statements, documents. And the objective of that is to really give you all the information, as much information as you can have to begin to garnish assets, those that are garnishable or those that you can collect on to be able to enforce a judgment. So some of those documents include bank statements for the last 2 years, tax returns for the last 2 years, titles of cars, a list of any type of jewelry they might have. There's just a lot of different assets they have to include. Title to the home, any money market accounts, stock certificates, anything of value that they own will be included as a fact information sheet. It's attached. Now that is sent to the attorney who is representing the judgment creditor, but that's not filed with the court. None of those documents are filed with the court. The only thing that is filed with the court is notice of compliance of service of the fact information sheet. That's the only thing that is sent to the court. Then the judgment creditor will decide what to do with that information, how to enforce that, whether it's garnishing wages, whether it's garnishing bank accounts. There's a number of tools that a collections attorney has to be able to garnish, to enforce that judgment. If the debtor has, say, property that is not homesteaded, something that is not a residence, that property could also be at risk for potential sale. So put a lien on that property and is forced to sell that property as well. So there are a lot of different tools available. But it's important to move forward with the fact information sheet as soon as possible. They don't comply with the fact information sheet, then we ask the court to file an order to compel discovery, to compel completion of that form. They still don't comply with that form. You can ask the court to issue a writ of attachment, which is arrest, bring them to the court and explain why they have not completed the fact information sheet, by holding them on contempt of court. The court cannot force anybody to pay per se if it's a judgment, but the court can hold somebody in contempt of court for not completing the fact information sheet. So I just want to make that distinction, that there's two parts to winning a case. You win the case, you get the judgment, you have that piece of paper says you're entitled to collect certain amount from a judgment debtor. The second part is the collections part. So it's not automatic. Now, there's also an issue here that because you won the case, the defendant has some options as well, or the other losing side has some options. One of them is to appeal the judgment. And without going into the mechanics of it, they have generally 30 days to appeal from the final judgment. They have 15 days. Before that, they got 15 days to submit what is called a motion for reconsideration of that final judgment to the court. And then the court that entered that judgment, then the court decides whether or not to reconsider that final judgment or to overrule or deny that motion. After that, then the losing party has the right to appeal it. That's a different conversation altogether. But I want to make it clear, just because someone appeals a final judgment does not mean that it stops collections. You as the judgment creditor can continue collecting of that judgment despite of an appeal unless the court agrees to stay collections of the final judgment pending appeal, which very rarely the court agrees to that. Or number two, the judgment debtor posts a bond with the court. Posting a bond means you got to write the amount of the check, the amount of money into the court registry, and then collections will stop at that point because at least the money is in the court registry. Should you lose your appeal, the judgment creditor will be able to collect on that judgment. So there are a number of options available here to you. Yeah, I mentioned this at the defense side. If you won, what can go wrong? Yeah, the opposing party can file the motion for rehearing. I just mentioned that as well. A notice of appeal within 30 days. It is important that you preserve everything. Just because you won the case, you don't start deleting or shredding documents or getting rid of them until the case is finally closed and after the matter is completed, including a potential appeal. Okay, that is an option that they have to do, and you don't want to say, "Oh, well, I threw that away." Your attorney knows to preserve evidence as well. It's important that if you're going to, once you win the case, it's important not to gloat on social media and listen, this can go either way. The reality is going in front of the court. Nobody's going to know what's going to happen. Nobody can predict what's going to happen. So I think any type of social media statements, I don't like them. It's good to just keep everything professional, especially if there's a reconsideration of any kind. You don't want the case to be reopened. If the other side is represented, say you won the case, it's good to still continue communicating through attorneys, not communicate directly with opposing counsel, or don't communicate with the party directly. Say, listen, I won the case, now you owe me money. No, just let the attorneys handle that. If you have a judgment, you have another option as well. There are companies that purchase judgments at a discount, and they handle all the collections. So say you have a $100,000 judgment, you don't want to be bothered collecting the money. You don't want to wait to try to see if you're able to garnish wages, or you don't want to spend the money on an attorney to collect. There are companies that will purchase that judgment. It's going to be at a significant discount though, okay? But there you can assign the judgment to another party, another company, and then you can collect some money, and then they handle everything else. They handle the collections, they handle the enforcement, they take the risk of the collections. You don't have to handle that. So that's another option as well, as opposed to having a piece of paper that you may or may not collect from. Possibly, if it's something that is an asset that you can sell, consider that as well. I mean, there's just very different options, but you're a judgment creditor. You do have a significant amount of options as well. Another option that you have is negotiation. You won the judgment, now you want to collect your money. Okay? In a perfect world, you want to collect 100% of what you won. But it's not a perfect world. The reality is money in your pocket is more important than having a piece of paper that has a number that you can collect from, and then spend a few years trying to collect. So oftentimes what parties do, you won, so listen, my client wants to resolve this matter. This is what we can do. We'll give you 80% of what the judgment entails, okay? It could be on a payment plan. It could be at different options. But you also can negotiate a potential settlement at a discount to get your money. That's, at the end of the day, that's what you want to accomplish. So there are a lot of different options. Your attorney can discuss those with you about what to do. And if you settle the amount, settle for any type of payment agreement, then you can go ahead and enter into a confidential settlement agreement, just like we talked before, and settle the case and get the matter resolved. So the purpose of this, of today, is that after you win the case, there's still work that has to be done. There's some work, post-judgment work that has to be done. A, seek the attorney's fees that you're entitled to. That's some additional pleading, some motions we have to do. B, make sure the case is completely closed and dismissed, so you don't have any type of lingering issues, any type of attorney's fees issues that might come back later. And that happened in a case that I had, that we won the case, happened a few years ago. We actually won on one particular account after appeal, the entitlement to attorney's fees. And there was one small motion lingering in the case before I actually got involved on some attorney's fees that the court awarded but it reserved. And that matter was not resolved. So even after we won the appeal, the attorney said, hey, there's one more thing we need to talk about because that one was not discussed and the court reserved it. So he brought it back again. So we have to deal with that particular option, that particular issue. So what I had to do is renegotiate some of those issues and say, okay, from this point to this point, this is all you have been entitled to. I'm entitled for the entire case because the Court of Appeal already reversed that. So we were able to negotiate something and then we got the matter resolved. But the point is that you just talk to your attorney to make sure that there are no lingering motions out there that could be handled post-judgment that surface after the fact. Because then dealing with, I don't know, it's a surprise, but the case law says you can address those after the case has been closed. So just kind of a lesson that I learned, and also it's also a lesson to go forward as well, that there's no pending matters that has not been resolved post-judgment, so you don't have to deal with. I think this is a good for today. The key here is you won your case. I mean, you're going to feel very good about that. The reality, cases are won or lost every day. There's no a perfect formula for that except preparation and presenting your case to the judge or the jury. And it is up to them to make the decision. I still believe that trying to resolve the matter out of court is still a better option because it puts you in control of the process versus allowing a third party who has nothing to do with the case make a decision for you on how to resolve it. But in some cases, settlement is just not an option, and then you have to present the case to a third party, like a judge or a jury, and have the judge or jury make the decision. That's what the system that we have. If you have any questions about any topics that we talked about today, feel free to email me at richsierra.com. If you want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. My telephone number is 866-842-5202. Remember that Business SOS, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. If you like this podcast, I hope you do. Please follow us and give us a 5-star review. I certainly would appreciate that. We also have the video of this podcast and our YouTube channel, which is doing very well. Very proud of that YouTube channel as well. And it's at youtube.com/@RichardSierra. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. And remember that my goal is to help you succeed.